Hi everyone, this is for Saddleback students enrolled in HS 119, Introduction to Criminal Justice. I'm going to cover Chapter 7, which was on the juvenile justice system, and I'll cover Chapter 8 as well, which is the conclusion to our course and all of the content that you guys have learned. So to date, you guys have come to understand how the criminal justice system works, how we come up with policy, why we have criminal justice policy. We've learned about what law is, the different types of crime. We've learned about law enforcing and policing. Today we had a guest speaker on the application process for applying for work in criminal justice, the background process, how that works. We've learned about institutional corrections, community-based corrections. So now we're going to cover juvenile justice, and then I'll go over Chapter 8, our conclusion. So if you have your outlines handy, this is our outline, and this is mine with all my notes on it for the things that we have to cover. But you can find your outline in the module for week 6. And you can refer to this as we work, or you can refer to our slides presentation. I'm going to rely on that as well. Starting with the beginning of our outline, I'm going to have you guys on your own go over the development of juvenile justice. I do want to point out one thing. On page 189 in Chapter 7, the juvenile justice system philosophy is that of parens patriae, in that when we decide to enter a juvenile into the justice system, the juvenile court acts as the parent. It makes decisions based on the youth's needs and what would best suit that individual, what would be an appropriate sanction or punishment for that individual youth. And so the parens patriae philosophy is that of the state as the parent. The state or the court looks to assist youth in solving their problems. And there's some legal basis for that as well. And I'll let you review that from your textbook. But the parens patriae philosophy also identifies that youth often lack the intent, the mens rea, the intent, the ability to form intent, and the ability to act on that intent and engage in criminal behavior. So we treat juvenile delinquency as deviant behavior, and sometimes we believe that that deviant behavior is beyond their control because they don't have the ability to form intent. So please make sure to review that, specifically page 189. Moving forward to the juvenile court process, please pay attention to pages 196 to 204 of your textbook. I'm going to briefly review some of the terminology from our outline. I'm going to go over detention, intake decision, transfer/waiver into adult court, adjudication, and disposition. So I'm going to compare these to adult court a little bit, since we previously learned about the criminal court function for adults. We learned about when someone is arrested, when charges are filed by the prosecutor or the district attorney, when somebody is arraigned, if bail is set, if someone goes to trial, if someone takes a plea agreement, etc. So I'm going to compare it so that you kind of understand or have a better understanding of how the juvenile court process works. But when a juvenile is arrested by an arresting agency, whether it's the police or probation or the sheriff's department or the highway patrol, whoever it is, there's a decision that needs to be made, and it has to do with their detention. For example, in adult court, we might decide whether someone gets bail, but juveniles are not entitled to bail the way we are entitled to bail as adults. So we call that the detention stage. We decide whether or not we will keep a juvenile in custody pending the duration of the juvenile court process. The intake decision is typically one that is made by a probation officer. In Orange County, we have what are called intake probation officers, and they basically review the arrest report they talk to the arresting agency or arresting officer, and then based on the circumstances of the offense and the juvenile and their living situation, will the DPO make a decision whether or not to have the juvenile go through the intake process, which in adult court would be like kind of the arraignment, where an adult is advised of the charges being held against them. So in the juvenile process, we call that the intake decision. From there, we have what's called a transfer/waiver into adult court. So prior to the passing of Proposition 57, which I believe was in 2016, in any event, I'm going to upload a handout for you guys about Prop 57, because Prop 57 impacted juveniles, but it also impacted adults in custody. But for the purpose of this presentation, we're going to talk about Prop 57 as it impacts juveniles. So historically, it used to be up to the prosecutor or the district attorney at juvenile court whether or not certain cases for juveniles were filed in the adult system. And it was typically violent offenses such as murder, rape, carjacking, and sometimes those were automatic adult filings depending on the juvenile's age. And Prop 57 changed that. Prop 57 took away prosecutorial discretion, or it took away the ability from prosecutors, district attorneys to determine and decide when a juvenile was filed in adult court. It is now up to the judges. So that discretion was taken away from prosecutors and it was handed back to judges. So if we have a juvenile who is being charged with murder, rape, and or carjacking, they need to be filed with juvenile court, and at that time a judge in juvenile court can decide whether or not it's better to try a juvenile in adult court. And again, I will post this handout for you in Canvas as a point of reference since our textbook doesn't talk about it. But we used to be able to transfer juveniles into adult court and try them as adults, but that discretion has been taken away, and so we now are trying juveniles in juvenile court, even despite the fact that some of their charges are pretty violent and heinous in nature. If a juvenile is transferred to adult court, they typically remain in adult court. If the adult court doesn't feel that they belong in juvenile court, adult court, if the adult court doesn't feel that the juvenile belongs in adult court, then the juvenile will be sent back to juvenile court. But let's say a juvenile is transferred to adult court and the charges don't stick. Maybe the case is dismissed or they're found not guilty. We cannot send the juvenile back to juvenile court and try the case again. What violation of your rights would that be? Your Fifth Amendment right. That's a violation and that would be double jeopardy, trying a person twice for the same offense. We don't do that. So if a juvenile is transferred to adult court and they remain in adult court, if their case is dismissed in adult court or they're found not guilty, we cannot send them back to juvenile court and have them tried again. It doesn't work that way. And not all juveniles are transferred. It's actually a rare occasion when it happens. It happens, but it's not the common practice. And especially since the passing of Prop 57, it has changed the way in which we can transfer juveniles to adult court. The adjudication would be like the conviction in adult court. So we don't say that juveniles are convicted, we say that they're adjudicated. Going back to the philosophy of juvenile court, we don't want it to be adversarial. We want it to be more of a helping, assisting type of court. We want juveniles to be assisted in their problems. We want them to be helped. We don't want them to be criminalized per se. We don't want them to have that stigma because we know how damaging it can be. So we try to make the juvenile court as non-adversarial as possible, so we don't use a lot of the same terminology in juvenile court that we use in adult court. So instead of conviction, a juvenile is adjudicated. They're either found guilty by the judge or they plead guilty. There's no jury trials in juvenile court either. Can you guess why? It's one of the constitutional rights that is not afforded to juveniles, the right to a jury trial. Again, we like to keep juvenile court as keep as many people out as possible. It's a very private, intimate setting where we're trying to work with juveniles on an individual basis, and we're trying to work with them and solve issues and problems. We don't want to make it worse by bringing in more people. Either the judge would decide adjudication or not, or a juvenile would plead guilty and would be adjudicated once pleading guilty. And then disposition is like a sentencing hearing. Disposition is where a juvenile would be sentenced to either some time in custody at a camp or would be placed on probation. One of the biggest difference between juvenile probation and adult probation is that in adult probation, adults have the option to either accept the terms and conditions or to not agree with them. And if an adult doesn't agree with probation, then the other option is to send them to prison without any supervision. So, but in juvenile court, probation is not an option. You are told and ordered by the judge to participate in probation. So juvenile court probation is not optional. It is ordered by the judge and must be complied with. In adult court, adult probation is optional. If you don't want to participate, you don't have to. We'll just send you to prison instead. Okay, those are the biggest differences. And the definitions for those terms are on page 7 of our slide presentation as well. On your own, I'm going to have you refer to pages 204 to 206 of our textbook when it relates to due process. There are 4 court cases that have determined juveniles are entitled to due process just like adults. Juveniles are entitled to counsel. They're entitled to legal representation just like adults. Juveniles are entitled to be heard and to be tried with the same standard as adults, which is beyond a reasonable doubt, the reasonable person standard. So we need to, when we're talking about juveniles going to trial in juvenile court, they're not being heard by a jury of their peers. They're letting the court or the judge decide their guilt or innocence, and the standard is beyond a reasonable doubt. It's the same standard we hold in adult court. And also, the other important point about federal court cases when it comes to juveniles' rights and due process is juveniles are not entitled to a jury trial, again, because the juvenile court setting is more of an intimate, non-adversarial court setting. Juveniles are not entitled to bail, and it has to do with we need to make sure that juveniles are present for their court hearings, and we don't always have confirmation that the housing that they're in outside of a juvenile court setting is appropriate. Or maybe we have confirmation that the housing they're in is not appropriate. When juveniles come through the juvenile court, it is the court's responsibility to make sure that they are safe and that they are able to return back to court as well. So we do not allow bail. We do not grant bail to juveniles. And we also make sure that the courtroom setting in juvenile court is non-adversarial. So there's 4 court cases you need to be familiar with. They can be found on pages 204 to 206, and they talk about due process and rights afforded to juveniles according to the Constitution. Okay, moving on, institutional corrections. So essentially when we talk about juveniles, some of the things we need to be mindful of when we are detaining juveniles, we want to make sure that their needs are being met. So they're afforded the same rights that adult inmates are afforded. Medical care, mental health services, because they're juveniles, they are entitled to education. And just about every juvenile facility up and down the state of California works collaboratively with the Department of Education to provide education to youth while they're in custody. There's also what we call alternative interventions. Let's say a juvenile has been charged with committing some sort of crime, but housing them at juvenile hall may not be in their best interest. Maybe we need to remove them from the home that they're living in, but juvenile hall is not the appropriate setting. That's when social services might come in and place a youth in a group home or some other type of facility. And when we talk about the de-institutionalization of juveniles, we're talking about not criminalizing or arresting juveniles for certain offenses. For example, status offenses. So staying out past curfew, skipping school, things like that. Those are not things that we would necessarily house a juvenile for at juvenile hall. We reserve a facility like juvenile hall for juveniles that commit serious or violent offenses, felonious offenses, offenses that create a risk or harm to the community or others. So when we talk about deinstitutionalization, we're talking about taking a low-level type of juvenile offender and not housing them in custody with a higher-level juvenile offender. Community interventions. So now we're talking about alternatives to custody or alternatives to detention when working with juveniles. So maybe the court will place them on probation and give them what's called aftercare. Aftercare can be therapy, counseling, maybe programming, maybe an anger management program, maybe an anti-theft program. The district attorney's office in Orange County for adults has an anti-theft program. So basically offenders who commonly enter the court system for theft charges, we can send them to an anti-theft program. There's programs like that out there for juveniles as well. When we house a juvenile in custody and they are released from custody, we also have re-entry concerns just like we do for adults, right? We have a juvenile who's going to need to get back into school. He or she's going to have to reintegrate back into their community, their neighborhood. They're going to have to return to their family life where they were living prior to being placed in detention. And then also there's issues in supervision, right? So for example, we have a juvenile who lives at home with their mom and dad. Mom and dad aren't on supervision, but the juvenile, the youth is. And so we need to make sure that the parents understand that when probation goes to the home to conduct a search, mom and dad or caregivers or parents or guardians need to be cooperative with that so that we can work with the juveniles, enforce the court orders, and make sure that the communities are safe that juveniles are living in. So those are some of the issues in supervision. And then moving on to special topics within Chapter 7, we have gangs, restorative justice, and capital punishment. I'm going to let you read about restorative justice. Gangs are prevalent. They're very much alive and well throughout Orange County and throughout our state. But in any event, gang involvement is very challenging when working with juveniles, especially when we work with a juvenile who is detained, housed in custody, housed at, say, juvenile hall or a camp, and then the juvenile is done with their commitment, because in juvenile court we call it a commitment, not a sentence, right? It's a commitment. And if we have a juvenile that we've been working with in custody and they're released back to the home and the neighborhood they came from, are they going back to a gang-infested neighborhood? Are they going back into their community where they were a gang member? So all of the progress they made in custody, it's almost like sometimes it comes undone when a juvenile gets released back home into the community they came from, especially if it's gang infested. It's likely that juvenile is going to re-engage with that gang and start engaging in some of those not so good behaviors again. So something to consider when we work with youth that are involved in gangs. And capital punishment, page 216 of our textbook. Please take a look at that. Roper v. Simmons, 2005, a majority opinion from justices from the bench decided that it was a violation of a youth's Eighth Amendment right to be sentenced to the death penalty. So it is considered cruel and unusual punishment to sentence a youth to the death penalty. That is a federal court case. And so this has created what we call case law, in that we learned about earlier. Remember when court cases end up becoming law? It's called case law. So we have case law, Roper v. Simmons, 2005. It is illegal to sentence a youth to the death penalty as it's a violation of their 8th Amendment right, which is a violation of cruel and unusual punishment if we sentence a youth to death. So there you go, Chapter 7 in a nutshell. Okay, let's move on to Chapter 8. Really quick, Prop 57, this is a handout that I found online. I'm going to go ahead and publish that for you, but it's a quick read. It's actually a really interesting read. This is from the LA County District Attorney's Office, and it's a brief summary of Prop 57 in its entirety, and it talks about how it impacted adult court filings of juvenile cases. So I'll post that in Canvas for you. You can find that in the module for week 6 under juvenile justice system. Okay, so Chapter 8 was a really short chapter. This is your outline. I think your slides presentation was like 7 slides. Oh my gosh, I think it's the shortest slides presentation I've ever put together. Anyway, so some of the things we're talking about in Chapter 8, we're wrapping up all of the content that you've learned during our course, and you guys have learned a lot. We crammed a lot of content into 8 weeks. You should be really proud of yourself. Give yourselves a hand. But when we talk about criminal justice and discretion, discretion is used at all levels of the criminal justice process. So from the time a police officer contacts you, and when that report is submitted, or if it's submitted to the district attorney's office, the district attorney can file it or not file it. They can kick it back for further investigation. The court uses discretion, and if you're sentenced and placed on probation, then your probation officer uses his or her discretion. It is just everywhere. Discretion is everywhere. And again, discretion is the ability to act or not act based on past experiences and training. In criminal justice, discretion is permissible and it is expected. Remember the letter of the law versus the spirit of the law, right? So be mindful of that. Discretion is at every level of the criminal justice process. Let's see. You guys, we've already talked about the opioid addiction and responses. I shared some video clips with you a couple weeks ago. If you go to slide number 4 in your slides presentation for Chapter 8, I embedded a couple different links on the new war on drugs, which is our current opioid crisis, the use of naloxone, it's a chemical that field officers, police officers are being trained in, also known as Narcan. Field officers are being trained in how to use it because of the amount and frequency of people ODing on opioids. So I'm sure if you watched in our video from a couple weeks ago about the opioid crisis, the documentary I showed you was on Ohio. And essentially, from what I recall from that video clip, a lot of emergency rooms would prefer that anyone ODing on an opioid be dealt with and handled outside of the emergency room. There's just not enough beds, enough staff, enough resources to take in every person who's ODing on an opioid, which is why officers, police officers, probation officers are trained in how to administer Narcan, naloxone, to counteract the effects of an opioid overdose. And I also recall from that video clip that I shared, an emergency room would much rather somebody who's already been dealt with in the field than to have to deal with it themselves, because there just aren't enough resources. And also I embedded a link on Health and Safety Code 1799.102, which talks about Good Samaritan laws. So as a citizen, if you see someone in distress and you offer assistance, you are protected under Good Samaritan laws if something were to go awry or not as planned. So make sure to review that. Technology and social media. So social media is a blessing and a curse. It's a curse because a lot of misinformation gets out there, partial information gets out there, and it's hard for us to kind of weed through it all and figure out what is accurate, what is not. But the blessing is that now we have technology where officers can wear body cams and we can take an entire event and have it recorded and study it from beginning to end. We can learn from it. We can use it as part of investigations, and we can use it as future training tools when we deal with other criminal justice professionals. So read up on that. One of the biggest things that I experienced in my career as a result of social media and technology was video arraignments. So one of the ways the court saves money is using video arraignments. So instead of transporting people back and forth from the jails, we have what are called video arraignments, where someone is literally arraigned on charges as an adult over video, over a live stream feed. It's one way courts can save money, and it's one way that we can start the court process a little bit quicker and get things moving a little more efficiently through our court system. So be mindful of that. One of the other things that I think is interesting with the advancement of technology is when I worked with probation officers in the probation department, a lot of officers I learned were communicating with the people they supervise, the probationers, through email. And when I was a field officer, it was a policy in our department not to email with offenders because of confidentiality issues, things like that. But now it's becoming more of a common practice, right? Officers are texting on their cell phones with offenders. They're using email, and they're using technology to communicate. Officers also use social media to conduct investigations and to gather intel on the people they're supervising, or criminals or suspects they might be conducting investigations on. So make sure to read on that in Chapter 8 and become more familiar with that. When we talk about fiscal austerity in the criminal justice system, okay, I'm not going to lie. When I started teaching this course, I had to look up the word austerity. So if you have to look it up too, no problem, no judgment here. But when we talk about fiscal austerity, we're talking about a set of political economic policies that aim to reduce government budget deficits through spending cuts, tax increases, or a combination of both. So basically, what is that saying? It's saying that the federal government, state government, local government is making decisions on behalf of the criminal justice system when it comes to spending. So basically, government entities will decide how money is allocated, how much money is issued or awarded to criminal justice agencies, and then criminal justice agencies have to find a way to make that budget work, to make that money last, to allocate it appropriately where it's supposed to go, and how to use it. So what's challenging for criminal justice agencies is when other government entities make decisions that may not understand the complexities of criminal justice. When they make those decisions, it's frustrating for criminal justice agencies sometimes to make that money work, to spread it out evenly, to allocate it accordingly, to make it last, to make it work. So it's challenging because we have some agencies that are in need of technology, that are in need of new equipment, but there's no funding because another government agency came in and said, you don't need that money, or we're going to give you money, but you can't use it for equipment. You have to use it for training, or you have to use it for the lease on a building. So that's what we mean when we talk about criminal justice and fiscal austerity, right? Because nothing's free. Everything costs money, right? Moving on, when we talk about criminal justice as a processing system, so we have a system of courts, law enforcement, and corrections, and they're all related, right? The 4 C's, right? Citizens, cops, courts, corrections, right? So, but at the same time, it's like a factory or a processing system. So if someone's contacted by law enforcement, a report is taken and filed with the district attorney. District attorney files it with court. Court makes a decision, you're sentenced, and now you're answering to corrections, because corrections is supposed to correct you and supervise you while you're in the community. But we have to remember we're dealing with human beings. So when we treat the criminal justice system as a processing system, we're taking away things like individuality, dynamic factors such as substance use, mental health disorders, learning disabilities, someone living in poverty who doesn't have as many resources or access to resources to somebody who's not living in poverty. So it's important that even though criminal justice may seem like a processing system, it's really not. We rely on each other, the different C's, courts, cops, corrections, right, and citizens. We all rely on each other, but we need to remember that people are individuals and they should be treated as such. Sometimes we have to make accommodations for individuals that we're processing through the system when maybe there was a time when we wouldn't. We're at a point in time where we do need to make accommodations for individuality and those dynamic factors. And that's it for chapter 8, you guys. I want to thank you for watching and joining. Make sure to take notes. I'll add the closed caption feature so that you can follow along. You are more than welcome to use this video lecture while you're taking your final next week. So be mindful of that. Thank you for a great 8-week session. I enjoyed working with each of you, and I look forward to working with you again in the future. Have a good evening and take care.